general commercial also, these residential zone. Their parking lot in the back is in the residential zone. This is where, for those of you who have been here a long time, this is where Kodiak Coffee was. Behind that, east of that, is where the Artist Studio Association parking facility is. You can see looking down more towards, there's the Artist Studio Association building there. Here it is. There's the Artist Studio Association building. This is that right-of-way that goes back all the way through it, and then this is the Martin House. Again, the Martin House here, we're looking down. You can see that the topography drops off, and beyond this lot, it just goes down as it goes down towards East Elks Lake Park. So there's a pretty good geographic separation between these properties and the remainder of the residentially zoned properties as well. I did this one just to put it in without the color so you can see a little bit better. Again, the zoning here, including the part of the building and the part of the parking lot is residential, but it's clearly on it. You can see a little bit better the Artist Studio Association parking lot down here on this lot. So this is, again, this is a situation we have where these are zoned, actually these are zoned multifamily residential, I'm sorry, I said single family, they're zoned multifamily. And we're recommending being zoned general commercial. And then the third group is just a single property. To give you an idea of where it is, this large white building in the lower left here is Radio Shack. And this up in the upper part on the left is Burger King. So these properties, actually one building, part zoned residential, part zoned commercial, and this is the building. You can see looking along the street towards the residential area. This building on the right here is commercial, as is building across the street, and there's where the zone would change from commercial to residential. And again, this is principally just to make the zoning match the reality of how these properties are developed at this point. Again, all the property owners either have asked to have this happen or want it to happen at least. And again, the principal purpose is to remedy potential non-conforming situations that might develop in the future. So that's what I have.
Okay, thank you.
Just a quick question, if I may. I saw how the others evolved the way they did. Can you tell me about this property just a little bit? How did that get developed?
I'm sorry, say that again?
How did this property get developed the way it did?
You know, I have no idea how it got developed that way. It's surprising to me that it did. It may have been downzoning on it. I just don't know. It was like that when I got here.
Yeah. Okay.
But I don't know.
Okay. Any other questions?
Yes. You indicated that the owners of the property were in favor of this action. As part of the process of rezoning, was notice set out to surrounding property owners?
Yes.
And what was the radius for that, 200 feet or 300 feet?
250 feet.
250 feet. And what was response, if any, did you get?
Zero.
Zero.
Right?
I had a couple of calls for the property up by the U.S. Market, just general inquiries about why they received the notice, what was it about, but no follow-ups with letters or public at this point. Just basic inquiries.
A question on the Layton Properties phone call, and again, there was no follow-up, and when I explained what was going on and what the change would be, the caller wasn't concerned.
So there have been no objections voiced by potentially impacted neighbors to these properties?
No.
Thank you.
Joan?
Just a quick confirmation. Did I hear you say that there were no additional nonconformities that were created by the rezoning? In other words, I was just wondering about the one property that's residential now, the last one you showed. If it goes to commercial, I didn't know whether there was a greater setback.
No, there would be no nonconformity created.
Okay. So there's no setback issue between commercial and residential property when these are rezoned?
No, actually, if we go back to that, actually, on the, there's actually on where the principal issue might be on the east side of that property, but that is, there's actually a public right-of-way there.
Mm-hmm.
There isn't that. And we still would have, if it's commercial, the ordinance specifies that if it's across the street from or next door to a residentially zoned property, the setback on that side would be the same as it is in the residentially zoned property.
Right.
Thank you. Any other questions? Nope. Okay.
What I would ask you to do is, when you make is to make motions tonight, to make recommendations to the council to do whatever you move to have them do, to approve the individual rezonings or not, depending on what you decide to do. So we have this scheduled for hearing at the city council next week.
So we're going to move to forward them to the city council, correct?
It's up to you.
If we
Something's going
choose
the
to
city
do
council.
that.
In one way or another, it's either going with a positive or negative recommendation,
Okay. Okay.
or something else, whatever you come up with.
All right.
Do we, Rich, I thought I heard you say that we needed to do 7 different,
Well, there's 7 different properties, or 7 different parcels. I think you can do it with 3 motions.
or do we have the language of that motion? Since it has all of those, it's not clustered in a way that they're grouped, are they?
I have it grouped as 6 different
Okay, yeah.
motions.
Okay. Yeah, that's right, so it is individual properties, yeah, because there's 2 SGWG or something like SWGW properties.
The reason for my question is I just want to make sure that whatever we pass forward passes muster because
Yeah.
the language was correct.
Big packages, if it's unanimous on all the properties, or do we need to do it 6 individual motions?
You can have a discussion on that after you finish your public hearing.
So,
Okay. Thank you very much. Okay, now is time for public comment and testimony, and we have no public tonight. If there's any person in the audience who did not sign up but wishes to speak, raise your hand. People, is there a comment from representatives of public agencies? No. Okay, if there's no further comment, is there a motion to close the public hearing?
Moved. Second.
Okay, all in favor?
Aye.
All those opposed? Public testimony is now closed. Now's the time to consider making a recommendation to City Council. So, I guess now we can discuss whether we want to do it, the best way to approach this.
Madam Chair, I think this is just a bit of house cleaning here. We're just housekeeping, making these changes to clean things up on the mapping ordinance. I think, my opinion, if we all agree that we could present this in a package instead of 6 individually.
Well, I would defer to the city attorney whether we can do it that way.
Yes, you can.
All right. No objection.
I guess the way I would suggest that you steer the discussion is if any one commissioner would like to take them separately, then you should do it that way. If no one commissioner elects to do it that way, and you all have a consensus that it's one motion, then you can do it by one motion. Like you had a thought.
Well, no, I'm in favor of doing it in one group, so if you're looking for a consent.
I agree.
You are?
I agree.
Everybody agrees?
I have a real quick question. If someone were to come in before the city council next week when this goes before the council and has an issue with one of these particular properties, is that going to, if we approve them all as one, is that going to make them have to do something to reopen the, okay, I just want to
No.
make sure.
All righty then. Somebody want to make a motion? How about you, Dennis?
I don't even have language in this one at all, but I would make the motion that we forward the mapping changes as written or as presented to us as a whole to be considered for rezoning as general commercial.
I was just going to, is that the end of it? Okay, I was
So
gonna
there's a
ask
couple
you-
of different, I'd have to have them right back up in front of me again, because there's some R1s, there's some
Okay,
multifamily and so forth.
my question is it your intent to make a positive recommendation or just to recommend that they consider it?
Recommend that they consider and agree to the changes or pass the changes, make the changes from the R1 and the multifamily residential to general commercial as presented to us.
Might I try to paraphrase the language in the staff recommendation?
Please do.
I would move that the Planning Commission forward a positive recommendation to the City Council to amend the comprehensive plan map and zoning map to redesignate the subject 6 sites from their current designation to general commercial by adopting the appropriate ordinances.
So with the commissioner who made the motion, do you agree to amend your motion as
Yes, I do.
so articulated? Okay.
Yeah, I found that page now, too.
Plagiarized.
Okay, so I think you're at a second. on
Excellent.
it.
Second.
Second.
Okay, Kate, can we?
Did
Who
you have a second?
seconded that?
I thought we fought for it here. Go
Yeah,
ahead.
we had
Yours.
2 seconds, yeah. We're good.
Okay.
We have a roll call, please?
Sure. Williams,
Yes.
Knutson,
Yes.
Kidd,
Yes.
Bryson,
Yes.
Evans,
Yes.
Shannon.
Yes. Okay. It's been approved. The City Council will hold a public hearing on this matter on Monday, July 23rd, 2012, at 6 p.m. Moving on, we have no old business scheduled. And new business, proposed zoning ordinance amendments.
Good evening. I'm just going to switch PowerPoints here. Okay, we have been in front of the commission before talking about these upcoming changes, and now we are at the point where we are going to be bringing you ordinances. Kate, is the date on that for the next meeting?
It's broken into 2 groups, and I think you're summarizing all of them tonight, but they're in 2 groups at the 2 August meetings.
Okay. All right, so the first is the sign ordinance, and we have a couple changes here. Alterations to non-conforming signs, we have a new addition to that part of the ordinance that would suggest that part or all of a sign that is non-conforming could still be converted to a changing image sign, provided that the changing image portion of the sign does not exceed the current size or height limits for a conforming sign. So, in this case, we have, we're showing a picture of a non-conforming sign. The limit on height is 20 feet. In this case, overall height is 27. And whereas we have a limit of 100 square feet, this is 240, so it's quite a bit larger. But With this amendment, the owner could change part of this sign to changing image sign as long as it is not above the 20-foot height limit or is not larger than the 240 square feet. Or, I'm sorry, 100 square feet. Okay. Any questions?
Yes.
Yes.
Yeah.
Oh, thanks. I remember there was some discussion about the rapidity of change, is how often, whether we have flashing images or anything like that. Is that still going to be in effect? That's not changed with any of this?
It still would be it's an hour.
Okay.
Right.
Thing a change.
Okay. Just one.
Yep.
All right. Thank you.
No change to the changes.
And didn't we have some discussion on this about grandfathering things in that were pre-existing, or?
Well, these are all grandfathered now that are non-conforming. That's, just another way of saying non-conforming,
Okay.
legal non-conforming.
And so we're going to make all these people reconfigure their signs?
Well, this actually loosens it up. This allows them to do some reader board type electronic component of an existing non-conforming sign. Right now, we wouldn't allow that.
And do you remember, because I know we had some representatives here from AG, or IAG.
IGA. Mhm.
And do you remember what their concerns were at the time?
Well, that's pretty much what they wanted to do.
Okay.
Andy Morgan was here, and he wanted to replace a portion of this sign with a reader board.
Okay.
Anything else? Okay. Also in the sign ordinance, this is a change that we are making. It right now says real estate signs. We are not allowed to regulate content of signs, so that is illegal, essentially. So what we are doing is changing the real estate sign reference to properties for sale or lease. That allows someone who is selling or leasing a property to put up an extra sign that we assume would probably be a real estate sign, but it might not be. If somebody who has a property for sale decided to put up a sign, a political sign, there would be no way to stop that. But our ordinance, by making this change, is legal in that respect. So it's a necessary change, I think, to keep the ordinance legal. And hopefully it will be used for the purpose that we expect. Questions about that?
Yes. The final sentence says, "It may not." What is it?
The sign, this extra sign,
Oh, the extra sign.
The-
It says you may have
yes.
one sign in addition to others.
they get one sign in addition to other signs.
Okay.
And that sign, okay, we can clarify that if we need to, but yeah, it may not.
Still, then,
exceed 30
you're still
square
falling in within the 100 square feet in total for all the signs on a property?
feet. This is in addition to.
Okay. All right, so if I've maxed out, and then I want to put my building up for sale, I can have that to
That's the intent of
got
that
it.
section.
32 feet. Got it.
Okay?
Yep.
And that type of sign does not require a permit. It doesn't, and I assume would not.
And it doesn't fall under any other requirements for signage as far as engineering and all that? I mean, I don't want to open anything up here, just a general question.
Do signs require building permits?
Real estate signs do not require building permits or sign permits.
So, just a question, because I'm not, what is the definition of temporary?
Well, in our code, we have a section called temporary signs, and in that we include a couple different things. The first is the real estate sign, or, now we're calling them signs for properties for sale or lease. The second one I'll be talking about next is the A-frame type sign. And Kate's our sign guru, so maybe Kate, with a temporary sign, do any of them require a permit then? Would the A-frame or anything?
An A-frame sign is not considered a temporary sign, although obviously seems temporary in nature. When you get a sign for an A-frame, when you get a permit for an A-frame sign, you can put it out every day forever. It's not for a period of time. We do require permits for different types of temporary signs, but they don't carry a fee with them. They're more informational than anything. So, for example, additional temporary banners. Sometimes a business will get a temporary sign while they're waiting for their permanent signage to be made, so they can have some identification out on their new business, or while they're just changing their existing sign out. But again, that's a sign permit that is informational, doesn't require a fee. But an A-frame sign is a sign permit that does require a fee, and it's permanent.
Okay.
Does that help?
It does. I think what's a little bit confusing is whether there is any temporal period of time that applies to a temporary sign. In other words, if a sign concerns the sale or lease of property, theoretically, couldn't it be there for 10 or 20 years?
It could be.
So is it something about the structure that is less, about the structural materials that are allowed that are somehow less permanent? I guess I'm just struggling with that. What's the difference?
Well, the one you're looking at in this picture is, looks fairly substantial, I guess.
I mean, it's certainly possible that at some point our building official could determine that signs of a certain size or height or a certain type of construction would need a building permit, even if they are signs advertising a property for sale or lease. We haven't ever done that, but it's possible.
Well, it's the traditional modes that we have of regulating signs, time, place, and manner restrictions, because they're the most objective. So I'm just raising a little bit of devil's advocate. Is it something to think about that some of our signs actually don't have a time component, even if we call them temporary versus permanent signs? And maybe only lawyers care.
Well, this sort of assumes a level of honesty or something where, because it's while the property is being actively marketed for sale or lease is the idea. And, there's a loophole there, obviously. But, it's a way to allow people to advertise their properties for sale without specifying that it has to say that it's for sale or lease.
Doug?
Yeah, I just had maybe something that's going to help answer that a little bit. I know we have a facility here in town that has what I would call a temporary sign over it, and it's where Shirley's Restaurant used to be. And I think Ramsey's Signs from Portland has come out and put "This is property of Ramsey's" sign over that signage. So is there any time period that can remain in? Because in a sense, that's advertising, but yet it's not part of the business that's there.
Again, the principal thing there is we don't regulate the content. There's two things going on there. They have a sign permit. That location has a sign permit, I believe. And
sign permit would be for Shirley's, not
it's for the sign at that site.
So Ramsey's.
What it says, it can say Ramsey Signs, it can say Shirley's, it can say, Go Cubs, it can say anything. And that's Chicago Cubs, not Newport. But one of the things, I think what's going on there, besides Ramsey Sign asserting its ownership of that sign, my understanding is with signs on 101, if it's blank for a period of time, ODOT considers it abandoned and will require its removal. So I think they're trying to preserve their rights relative to ODOT.
Let me ask kind of a follow-on question dealing with the temporary signs, and I use it in quotes because the word apparently doesn't mean anything in this case. But let's say, for example, this sign is up and it becomes essentially abandoned or decrepit. becomes an eyesore. Do we have any way to step in at that point in time so that, let's say, if we ever get into a down economy and a lot of things are up for sale, that we don't create our own version of sign blight through temporary signs?
We have a provision relating to dangerous signs. Just trying to think of what else there could be. I don't know if the property maintenance code addresses signs specifically or not.
Structures, I think it,
Structures.
for structures, so
But
probably
is this a
would include
structure
signs.
if you haven't given it a
A
permit
permit?
and you haven't done anything to classify it as a
The
structure?
zoning ordinance there's a lot of strange things in there. Like, I think a structure is a building, and the building is something connected to the ground. So conceivably, yes, although the
Well,
property
you know,
maintenance code isn't part of the zoning ordinance, so we'll have to.
I guess what I'm asking is, if the purpose of the exercise is to clean up code so that it's functional, that let's take the opportunity, particularly here, to add some language that either limits the duration or the engineering or the structural integrity or the appearance of these non-temporary signs that can be there for as long as the property owner wishes, if I understand you correctly. It seems to me that we could take this opportunity to really clarify that so that in the future, we don't have a lot of eyesores up and down the highway.
I think I feel like I have to say something here. Our verbiage up there says that a property actively marketed for sale or lease, and I think that would be somewhat limiting in the length of time that the sign could be there, somewhat limiting, because they would need to be obviously signed up with a real estate agent. I guess it could be for sale by owner, couldn't it?
That's
I know-
exactly correct.
And just to show you that there is a loophole there, and it's a big one. I know of one property in town that's had a sign on it that's for sale for at least 14 years. It's vacant, but it has a for sale sign on it.
But it's actually,
I became planning director.
but it's a for sale sign, correct?
Right.
Okay. I mean, I think there may be a way to change the verbiage a little bit, and off the top of my head, I can't at the moment tell you what that would be, but I think the intent's there, and there's always going to be a loophole. I mean, if someone wants to find a loophole, they're going to find one. I mean, in this case here, you could say, okay, I've got a business in town, I'm going to put it on the market for $15 million. It's only worth a couple $100,000, but I'm going to market it for $15 million. But what I'm going to do now is use that 32 square foot to create another sign on my property, and now I can do that. Is anybody in town going to? Hopefully, no one in town is watching this and deciding to do that now after I said that. But still, there's always going to be a loophole in this. But I think the intent's there. I think that's going to. I mean, temporary is basically something like a for sale sign or a campaign sign that you actually can see the light at the end of the tunnel. It's going to end at some point. And it's either going to sell, be pulled off the market, or the campaign is over, things like that. If down the road we need to go back and define what temporary means or make a stab at it anyway.
I would respectfully suggest that now do that since we're going through that exercise.
Well, I understand what you're saying. I don't know that are we going to sit up here tonight and define what temporary means?
Well,
without going home, I think
we'll give some thought to that before we come back with the
That's what
actual
I
ordinance.
Yeah, I was going to say, we can.
We have drafted an ordinance that we have sent to the Department of Land Conservation and Development, and that we have sent out to residents. But if the Planning Commission, this is the reason we hold hearings, is so that if we identify a need for a change in the ordinance before it goes to council, then we can do that.
I'd like to make a suggestion, just when you're thinking about the changes you might or might not want to see, or reviewing the suggestions of staff, that if you think about it a little bit from the end product, enforcing, sort of looking backwards, I think the city would be in a very difficult position to try to determine whether a property was actively being marketed. That's just not a position anybody it's an impossible proof situation. But 5 years for a permit is objective. That's why we use those clear things. So there's nothing that says you couldn't have a renewal. Maybe that's something to consider if the 14 or 20-year time period somehow doesn't seem temporary. But it's just a suggestion and a way of looking at it. You can sort of test it both ways. Do you know what it is going forward? Does the average person, can they identify what the criteria are for this sign that they want to apply for? And then from the city's perspective, later on, can everybody pretty much know whether that sign is still a valid sign, or is there some reason, some criteria that's no longer being met?
Well, again, it goes back to my underlying concern, which is the word temporary has no meaning, just like the word actively has no meaning or no enforceability without some definition. If temporary means 1 year, it should say 1 year. If it means 5 years, to your point, I think it should say 5 years. And I agree with you that the word actively, is a hollow phrase. I mean, it doesn't help us if 5 years down the road this sign is up, but the plywood is delaminated. There is no building permit. There is no structural. We have 100-mile-an-hour wind, and this thing comes flying apart, goes through a window or a car. I think again, part of the purpose of this is to not create eyesores, not to create, I would imagine, a series of attractive nuisances up and down the highway. And I think we hold the normal business owner to a fairly high standard regarding signage, square footage, whether or not they can have flashing once an hour, once every 30 minutes or whatnot. In this case, there is no standard other than 32 square feet. It's wide open.
Well, whatever standard applies to the other signs as far as being dangerous would apply to this section also.
Does it?
Yes.
There is a section of the code I was looking up while you were talking about this. In the sign ordinance, it talks about unsafe and unlawful signs, and it's a decision of the planning director if he finds that any sign or other advertising structure regulated herein is unsafe or insecure, is a menace to the public, is abandoned or maintained in a dilapidated condition, or has been constructed or erected or is being maintained in violation of the provisions, then the planning director gives written notice to the property owner, and it can be enforced as a nuisance under the nuisance provisions of the municipal code.
Well, that answers my question, other than the phrase temporary.
Well, for me, temporary means when the need for it ceases to exist, it will cease to exist. So if I've sold that property, there won't be a for sale sign up on it any longer under my ownership. It will cease to exist. If I sell a business, that sign could stay with the business if I'm selling as part of it. So that's how I read temporary. It is meant to go away when that activity occurs.
Okay, do you have the code up? Can you see if we have a definition of temporary in there?
And I just have a concern. I want to state this right. When we start talking about eyesores and blights, and it raises all kinds of red flags because it's so subjective. And I don't want another visit from a city official saying, someone said your sign looked terrible, and now you got to spend $500 to replace it. Those are my concerns when we start heading down that road. Is it that big of a deal? Do we have a problem or a solution in search of a problem?
Well,
it's my property. It's a sign. It's not going to, it's 200 feet back off the road. I don't know of any sign-related fatalities in Lincoln City lately. I just want to make sure why are we doing certain things, and do we need to do them?
Again, I use the word defense in quotes of what I suggested we're going through a lot of time and effort and money to create pearls up and down the highway. We're putting in money for people. We don't want to be doing things that are working at cross purposes. Things that may be working at cross purposes, I guess.
And I get it. I really do. But I also kind of want to defer to my private property rights. My idea of what's right and decent versus yours.
Well, all I'm
think of a
asking,
couple of signs around town, I go, these are disgusting or gross, but it's not mine. It's theirs, and
well, all I'm asking or all I'm suggesting is that we have a crisp enough definition of things, such as the word temporary or actively, such that when the planning director needs to do an enforcement.
that's
He's got some
quantifiable, and
teeth.
I'm on board with that. Yeah, absolutely.
I'm not trying to set some arbitrary standard. I'm
Yeah,
trying to give some precision to the use of the language so that it's enforceable if it has to be enforced.
Right, yeah, I can appreciate that, definitely.
Did you find it?
So the definition of temporary sign in the sign ordinances means a sign intended to be displayed for a specified period of time only. So within the code, though, I know that wasn't very helpful, but within the code, there are other types. So then it goes on to say a type of temporary permit that can be for 60 days and renewable once. And those are the types of temporary signs generally pulled by people who are waiting, a new business, for example, that's waiting to purchase their new signage, and they still want to have a presence, let people know they're open. So those are the 60 days that can be renewed once. There's another type of temporary sign permit that is called an additional temporary banner, and that's once a year for 30 days, no larger than 50 square feet, and it doesn't look at whether you've maxed out your freestanding or your attached signage. It's just for special events, basically.
But there's no definition of temporary regarding this.
There is not. Yeah, there is not. And the other one that is defined with a time is political signs. And those are set for a period before an election and need to be removed within a certain time after an election.
Well, does it make sense then to have does it make sense or not to have some time limit on this type of temporary sign? It doesn't need to be 30 days or...
My suggestion is you've really raised the issue, and let staff come back and make some suggestions or a recommendation.
Okay.
Which is what...
And prior to this, well, currently, we allow real estate signs, and we don't have a specified time limit on the real estate signs. So what our intent here is to take out the name real estate and describe it in some other way, not to necessarily change the rules that apply. If we do change the rules that apply to for sale and for lease signs, I think we would have a lot of people coming to talk to us about that.
Well,
that would be my...
Again, that's the purpose of the process, but I can tell you that there are multiple signs for real estate for sale that are falling down, that are buried by brambles, that are faded beyond recognition, particularly in the north end of the city. It doesn't read well to me to have that kind of temporariness as a refuge for lethargy.
Mm-hmm. Okay. Well, let us address that next time when we come back.
Thank you.
Okay. The next sign issue is we did not go, when we came before, we were talking about whether or not we would want to expand the possibilities for A-frame signs into the public right-of-way, and we withdrew from that. We had, even at the staff level, a lot of concern. We had concern when we talked at the Planning Commission before. What we did, though, is we cleaned up some of the criteria for these signs. As you may recall, currently the ability to have an A-frame or sandwich board sign is tied to your overall conformity of other signs on your lot, and the area is part of the aggregate allowed for signs of different types. So it was pretty complicated. And with these changes, we would just be allowing one sign of this type, but it would be on private property. It would not be in the public right-of-way. So that's really what all of this amounts to. Yes.
Not to be your nemesis tonight.
That's fine.
But 12 square feet divided by 3 is 4.
Mm-hmm.
But no dimension shall exceed 3 feet. Area 2, or section 2B.
That's a good point.
That the math doesn't.
It should be 4.
Yeah, it was.
It
That's
should
what I
be
remember
4.
the discussion was to a maximum height of 4, I think.
But that's
Also.
fine.
Is that okay with you? Yeah. Is everybody cool with that? Yeah, we'll make that change. Thank you for pointing that out. Let's see, the next thing. Okay, the last thing we did with this ordinance is to really beef up the enforcement part of it, especially as it relates to signs in the public right-of-way. And if, right now, I've crossed out on the bottom in smaller print, this is what we have currently, and it's basically trying to get at the same thing, but it doesn't spell it out the way the police like to have it spelled out. Because if they're going to confiscate a sign, they want it very clear what the rules are and how they give notice when they're able to destroy the sign if no one claims it. So that's what this is about. If they deem it to be less than $10 of value, they can dispose of the sign without notice. If it's greater than 10, then they will give notice to any property owner that they are, or anyone owner that they're aware of. If they do not know of an owner, they'll still keep it for 20 days before they destroy it.
Do we need to clarify that less than greater than $10 of estimated value?
Well, this is not the way the ordinance would look. This is an abbreviation of the way the ordinance looks. Okay, is there anything else? Yeah, you don't like that, Don.
Does it apply to any other private property? If I leave something in the right-of-way, can the police come and grab it and destroy it based on their decision of what the value is?
Anything other than a sign, you mean?
Yeah. Are we just
You
saying,
abandon your car in the public right-of-way,
if I
yes.
leave my jacket on the sidewalk, can they pick it up and destroy it? I'm just asking. We've said that we're
I think if you have property that's abandoned, that's a different issue. What we're talking about is something that
Is illegally placed.
is illegally placed because...
So if I leave my bike on the sidewalk...
No, we're not talking about other stuff. We're just talking about
It
signs.
says something, I understand it says sign. I just want to know, are we saying this segment, I'm not getting my words right. We're saying this group of people, because they put a certain piece of property in this right-of-way, now get to have it removed and destroyed because we don't want it there. But it doesn't apply to any other piece of property that's left in that same space.
If people leaving their jackets in public right-of-way became an issue, we could write an ordinance for that.
I'm just, it just seems to me, I just, as a business owner, I really am hesitant to get behind the police showing up with a tape measure and saying, oh, this is out of it.
This is actually a really big issue. It's a very big enforcement issue. It's one that I've dealt with in many cities, and actually cities have approached it various different ways. What they find is most people, the majority of people who have put out signs that aren't permitted signs in the first place don't care. They're not coming back to collect the sign. It's a throwaway value for them. And if they do care, they'll come back and pick it up. If they get a notice because it's a more valuable sign, they'll come back and pay whatever they need to pay to get it out of HOC, if it's collected by Public Works or whatever. And I think cities that have started that system have found that within a short period of time, actually word gets out, which is the best thing, which is that the city is serious about enforcing that, and so the amount of violations tend to go down. and it relieves the city of the liability issue, because they're able to dispose of them.
And I totally get it. I understand. We've been doing the devil's advocate thing tonight,
If you built a structure in the public right-of-way, we would tell you to either remove it by a certain date or we will remove it.
Right, okay, I'm just thinking the scenario where I have my business. I could put an A-frame out. It's still not in the right-of-way, but it might be. I mean, I've got a pretty wide sidewalk. Technically, someone could say it's in the right-of-way, even though I've got more than enough room, and seize it. Okay, and then it's up to them to decide whether it's going to be destroyed or not me, not you.
No, if you claim it, if you...
It says if it's under 10, and
Oh, okay.
who's making that decision, I don't know, they can destroy it. So my point is, if I have a bicycle in the same space, I'm not meaning for it to be abandoned, I haven't lost it, but I've put it in the same space. Can that bike be taken, or is it just business owners with signs?
Bicycle might be a bad example because it'd be the same as a car or something. We allow...
I'm just talking about private property in
telling
the
you.
space.
Well, let me finish.
Okay.
We allow vehicles to use the public right-of-way. It's like a person. You could stand on the sidewalk. You could have your vehicle, you could leave your bike there, you could leave your car there. That's one thing, but there is concern about using the public right-of-way, public property, for a private benefit, which is what the signs are. It's advertised using a public resource to advertise your private business.
Okay.
And the idea is that's an abuse of the public resource. So we want to nip that.
There are two other very important criteria that the city looks at when it's trying to protect the right-of-way for the purposes that we have right-of-way. In addition to pedestrians and traffic, we have Americans with Disability Act criteria that we have to observe, and we also have sight distance. So that sight distance is an issue for pedestrians, people on bicycles, people using mobility devices, in addition to people traveling in vehicles. All those things combined, when you add more legitimate uses of the right-of-way, including signs, you have to address that mix. We may not have any regulatory authority over other objects that are abandoned, but my guess is that we do, that Public Works could pick up any kind of abandoned items, because there's a risk that if the city doesn't do that kind of regular cleanup,
Right,
somebody gets hurt, we have that liability issue. So it's trying to balance all those issues, and where it's possible, say, we think we can include a potential for some limited use of the right-of-way for signs. Now, the way some cities do it is they say, you can only have signs in this location. In other words, the 4 busiest corners of the city where all the traffic lights are and where everybody is congregating, we're not going to have any signs in the right-of-way, because everybody needs to see in that area. We don't want anything blocking sight distance. Other locations, maybe sight distance isn't so much of an issue. The city engineer can weigh in if you're applying a location criteria. That's why it's hard to take just one criteria and say you can do this or you can't do this, and it tends to be a more complex approach, which I think is what you're going to be asked to look at when you look at addressing the ordinance. And it's not just for you or your business, it's for the use of the whole entire city of the right-of-way. So I guess I would ask you to take the broadest possible approach to
And I am. I
those
thank
changes.
you for that. I am considering that in my thought process. Whenever I see seizure, it bothers me.
Okay, we'll look at that.
Yeah, thank you.
Is there anything else on this, on the signs? Yes, Doug?
Just general comments, maybe, perhaps. Out of curiosity, how would you classify a windsock that had an open sign on it? And that on the windsock that was spinning in the air had the words "open," and it was hanging on a fish pole from the building.
Well, we don't care what it says,
Okay.
but, and Kate can tell you how she regulates windsocks.
I don't. They're flags, essentially. I'll let Richard weigh in on this a little more.
I believe actually windsocks are illegal.
Are they?
They're considered a moving sign, a flashing sign.
If they have words, if they have words on them, but flags or banners, you've probably seen any number of flags throughout the city with an open.
Well, yeah, I mean, that is just their advertising. They fill their entire frontage, the whirligigs and whatever they're called.
Well,
I'll
we'll
buy
have
the
to come
fact
back
that
with
the
that.
words are irrelevant.
So you're raising the question about that.
I'm just trying to get a general idea. You know, we speak about signage, but if I have a pole out in front of my house that has a kite flying off of it, it doesn't say anything, but it's saying, hey, you know, I might sell kites here at this location. And yet, that's kind of a signage. To me, it's a sign.
And-
Well, I know in the past, flags have been an issue. For instance, I think it's Perkins who used to put out the giant American flag, and it became sort of a symbol of the business, you know, that they'd have this giant sign. And so then you have the question, is it a patriotic gesture or is it actual signage, you know? So
Anybody flying the American, very patriotic. I'm talking about if somebody has spinners sitting out in front of their property and they happen to sell spinners inside their business, or if somebody has a pole that has like a sail shape and it's out in front of their business and it says open, is that considered a sign?
okay, we'll write up something next time about signs and how those are regulated.
And then I got some more questions.
Okay. And go ahead.
Well, I was going to give you time to make a note.
No more water for you.
I bet somebody's already made the note. Okay, so go ahead.
What about holographic signs? So if I've got an A-frame board out there, got holographic foil paper on it that kind of, when the sun hits it one way, it just shows one color gleaming at you and says one thing, and when light hits it another way, you look at it another way, it says another message. You know the kind of signage I'm talking about?
I believe so.
Those, I think, can be very distracting to drivers. I think it can glare at their eyes. I think that can be a hazard to the public, those type of signs like that. Are we going to be addressing things like that?
We'll try to include something in the same report. The ordinance doesn't address holographic signs currently, and what we do regulate essentially is the size, the location to some extent, flashing lights and that kind of thing. So, you know, it may get into something like that, but I don't think we've got anything right now.
Yeah, actually, really, don't think we've seen anything like that here. But it wouldn't be considered illumination, and that's when our code talks about illumination, whether it's internal or external, not creating glare onto properties or the right-of-way. So I'm not sure that we could get at it that way, since it really isn't illumination. It's a
In a sense, I
it's a
suppose
finish.
it's changeable copy in
It's
a
a
sense.
finish
So
more
sort
than
of a
anything.
low-tech, reader board. Limited reader board.
So we've talked about kites, how they can be signage. Have space, because I can think of several businesses in town that have a lot of movable loading that are out there. I would tend to look at that as signage. But I mean, it's attractive. I'm not disregarding that. It's kind of fun to look at sometimes.
One more, I'm sorry. Are you done?
No. Free discussion.
Oh, no, I was ready on a different tact. I didn't mean to interrupt. Human-held signs.
Pardon me?
Signs held by people.
Oh,
Where does that fall
Okay.
under?
They're unregulated.
sandwich boards?
Signs.
Will work for food.
Just holding a sign up, or...
We've got 40% off at the mall. Come shop at us.
And those tend to be in the right-of-way.
I'm just curious if we've addressed that in any way.
They're unregulated at this point.
Signage.
you raise issues, this kind of issue gets into, if we start saying you can't have a person holding a sign in the street, then we're getting into some serious free speech issues.
I'm not
and-
saying that we
so-
can't have that one, but I'm saying.
No, I'm just saying that
the same
it's not-
category as signage, and we should be, outline our parameters for it, or we should be looking at considerations, how that falls into our ordinances. We should be aware that that goes on, and that is signage.
So then what you're saying is if I can't walk down the street holding a sign, then I probably can't wear a sweatshirt advertising my business. Is that what you're saying?
I'm not.
Somebody here, I don't know who that guy was.
I think
It's signage.
what you're saying is that it's signage, and what the planning director is saying is, yes, and we don't regulate that, and I don't think there's any intent to regulate that. You could carry a sign that says, the end of the world is near, or you could carry a sign that says, free pizza.
But if you're saying-
It doesn't matter. You can carry that sign as long as you're not, violating some other law that, would the city have any interest in regulating that? I think the answer is no.
Creates jobs. We're all for that. You can hire
Exactly.
all the businesses can hire someone to stand out and advertise their business. It's not regulated, so it's a good thing, right?
Well, it's outside the scope of our proposed ordinance
Right.
changes.
That's-
I can
yeah,
tell you
I mean,
that
yeah,
much.
very well put.
The $10 an hour sign gets pretty expensive, too.
That's right.
And then one final point.
Yes.
So what about a structure that had held a sign? It's
What?
been-
The post that held the sign,
Yes.
for instance.
And it's totally,
The sign is gone, but the
Frame is
posts
gone.
are still there.
but the structure has not been removed, and it's fit over, and, it's a major job to replace it, but if they ever put something else up, somebody's going to have to get rid of this. That's not, that falls back to the planning directors.
The property maintenance issue.
The
Yeah.
abandoned signs, yeah.
Are we okay to go on?
I think I know what pole you're talking about, too. so.
Huh.
Really? Is it close to the city hall?
Yes?
Okay, we have a group of amendments that are fairly minor, we think, and they're kind of this is kind of the cleanup ordinance. Yeah, you never know, might not be. The first one adds duplexes as permitted uses in the general commercial and in the recreational commercial zone. Right now, they are conditional uses. And because we allow for single-family, and typically in duplexes in other zones as permitted uses, we are proposing that we do the same here. We are suggesting that we require CUP for drive-throughs in the RC zone.
Just, CUP is conditional use permit for those people watching at home.
Yep, sorry. And right now, we don't mention drive-throughs at all in the RC zone, so this is a clarification. The third one, and stop me anytime you want, the third one, we regulate churches, but we find that sometimes a church that's just starting out is not building a church building, and instead they're just locating in a storefront. So requiring them to go through the CUP process, conditional use permit process, to have a meeting, church meeting in a storefront seems to be excessive. And there's really nothing for us to say about that in terms of setbacks or, ways to make sure that it doesn't affect the neighbors. It's just like any other kind of gathering place. So what we have proposed is to define churches as buildings constructed for a specific purpose, and that is for gathering place. Isn't that about right? Richard, is there anything else that I haven't? Okay.
Well,
I see some frowns here.
Let me jump in. Church is being defined as a building constructed for a specific purpose. Do I understand that correctly?
Yes, so we're talking about the structure, not the function.
Well, I think you're getting into a real gray area there because, for example, let's say a person has a home in a RC zone or something, and they want to use that as a church. It was never built to be a church. It was never designed to be a church. How do you deal with that? Most small churches start out as either as a home or as some secondary use to an existing structure, whether it's a office park or something like that.
That's what I'm saying, a storefront, for instance,
Well,
a
it's not
retail
store-
space.
It's not even a retail space. It might be a
We've had
commercial
some of those, but,
Right.
yeah, okay.
So,
Well, if it's a building that is meant for human occupancy, that would be the first test, whether they could call it a church. You couldn't have a church in a storage unit, for instance. But it would be hard, I think, at that level to say that you could not use your home for a church gathering, but
all right.
without saying you can't use your home for a card party or a potluck. I mean, I'm not sure that we can make that differentiation.
Once again,
I think you're doing that, if I understood what you were suggesting.
Well, I think what's important here is what we're doing is saying a church has to go through a conditional use process, which is a building built for the purpose of religious services, whatever. The kind of thing we're talking about, the storefront, or you're talking about in somebody's home, the small group, does not have to go through that conditional use process. That's all we're trying to do is say that if you're going to build a new building for a church, it has to go through conditional use.
If you're going to build any building, it has to go through it, whether it's a church or not.
No.
Actually, I think under RLUIPA, you may be correct. So that's something we will need to look at. In other words, we can't discriminate against a church.
Treat a church differently
Treat a
than
church
another
differently
gathering place.
than another gathering place.
Right.
So if you want to have a building for the purposes of yoga retreats,
Okay, I agree with that. Yeah.
you would have to go through a conditional use permit. Is that the
Right,
intent?
but if you built a store,
Store.
you don't have to go through a conditional
I
use.
guess what I'm struggling with, because there's probably not enough information up there, is what is the problem we're trying to solve?
The problem is that we have individuals coming to us and they say, we've rented a little space, or we want to rent a little space in this retail store, and for the purpose of holding services, of having a gathering. And we say, a church, and they call themselves a church. And then we go to our code, and it says churches have to go through a conditional use permit. And we know that when that was put in there, the intent was not to prevent somebody from using a small, previously constructed retail space for the purpose of a gathering. It was that if someone is building a new facility that is going to have a large parking lot, is going to have people coming and going, and have other kinds of characteristics that might require some special consideration that the neighbors should know about before it happens. That's what we want to get a conditional use permit for, not for the little startup.
I think, again, without seeing all of the specifics of the language, it seems to me it's a little framed.
Okay.
Right now, because I think the purpose is commendable to not put church or other types of group gatherings through a conditional use permit if they're in an existing facility.
Right, that's
But
the
I
intent.
think by stating that definition, then you're moving off in another whole direction that may be causing more problems than you set out to solve.
Okay. All right. The next one is, when we did our landscape requirements a couple years ago, we included a limit on impervious surface for driveways. We said anything more than 18 feet in width has to be a pervious surface rather than impervious. And since then, we've had a number of contractors say, the typical garage width is 20 feet, and so we end up having to do 2 feet of a different type of surface, and it would really be great if we could just make that 20 feet of impervious, and then anything beyond that would have to be pervious. The idea was we wanted to limit the amount of hard surface that water could not penetrate, thus reducing stormwater runoff. But if 2 feet is an issue, we thought we would propose that increase to try to accommodate the typical driveway width.
Well, these are for residential driveways.
Yes.
Does it state that?
Let me see what it says exactly in our code. It says for single-family dwellings and duplexes, driveways, parking areas shall be limited to 18 feet, so it's specific. All right, and the last one. This is for parking lots. We have some parking lot design standards, and they show a 24-foot width for driving aisles within a parking lot. And we have seen elsewhere that they get by with 20 feet, and so we don't want to require more than is necessary. Again, with the idea that we don't want more hard surface than necessary. So we are proposing a reduction in that driving aisle width within parking lots.
Okay, I'm confused. So we're going to say they can never go beyond 20 feet?
We're saying that they only have to be 20 feet. The driving aisle, when you back out
Right.
from your parking space, the driving aisle for a two-way, right now, we require 24-foot width for that, and we would only require 20-foot.
Okay, so they still have the
So
freedom
it's
to...
loosening it up a little bit.
Perfect,
Yeah.
okay.
Less requirement.
What has anybody actually measured the impact of this change, say, with a couple of Dodge 3500 quad cab long bed trucks,
It's tough.
back, nosed in, as to how much you really wind up with?
We don't want to build for F-350s, as if everybody had F-350s. It's like building for Black Friday, building parking lots for Black Friday, where most of the time you're not going to use it. We recognize, there's going to be circumstances where there's going to be a big vehicle, and you see them, they'll take up 2 or 4 parking spaces, so they don't have the issue that of trying to fit into a space that they can't fit into or can't turn properly. And it's one of the thrills of having a big vehicle.
Some people who develop parking lots will allow some spaces for larger vehicles. In fact, we require RV parking, a certain number of RV parking spaces. But this would leave that up to the discretion of the designer. Anything else on the miscellaneous? Okay, garage setback. We had a discussion about this at a previous meeting, and we talked about whether or not we wanted to allow someone to build over that 20-foot setback that's required for garages from the right-of-way line. In this case, we've got a cantilever, and the ordinance proposes that we allow cantilevers to encroach into that 20-foot setback. Anything on the second story would have to observe the 7.5-foot setback requirement for the building, but not the 20-foot for the garage doors. And primarily, the reason for the 20-foot setback is so that cars can be parked in front of the garage, and because typically people back their cars out and then they leave them there for a period of time, or they fill their garages up with something, and they have to park in the garage, in the driveway. So anyway, that accommodates the vehicles. But on the upper stories of the house, or we question the reason for having a 20-foot setback there. So we are bringing this forward. We are distinguishing between a cantilevered deck or a portion of the second story as opposed to one that would be supported by posts. And the reason we're doing that is once you have the posts, then it's pretty easy to put in the wall, and before you know it, you have an enclosed space, and you've lost your 20-foot setback. So if it's cantilevered, the ordinance amendment would allow it to extend into that 20-foot setback for the garages. So then, we just had to throw this in about, how far could a cantilever project? So, these are just for fun, but it does open the door somewhat, as long as it's 7.5 feet back from the property line. Any questions about that? Okay. Natural hazards, Part 2. We did a natural hazards ordinance last year. We worked on it for quite a while, and the council worked on it for at least as long. At the end of the process, they still wanted to make a couple changes that we could not make because they required comprehensive plan amendments. One was in our comprehensive plan. It said that the applicant for a permit within a geohazard zone had to get a geotechnical report, and if the city felt that we needed peer review of that report, that the applicant would be responsible for that cost. And the council was not comfortable with that and asked us to change that. So that's the first one. If we decide we need a peer review, the city will pay for it. Secondly, we have a 1978 hazard map that it's been around so long, and it predates modern mapping techniques, and we're not sure exactly what it means. We know that there may be hazards in those areas. We're not sure on what line of, what of the designated line on the map the hazard is important and or imminent. So what we are suggesting is that we use that map as advisory, and when someone comes who is proposing a development, we look on the map, we say, well, it looks like you have a marine terrace with sporadic ferruginous aquicludes, and you should seek professional advice about that. So, or an ancient slide, or, we have a number of things on that. When we did our update previously, we adopted new data, 2004 data from Priest and Allen, they're from the Department of Geology and Mineral Industries, and based on new mapping methodology. And we feel very comfortable that it's fairly accurate, and that is specifically for coastal erosion. For the rest of this, then, this would be advisory only, and we would not require geotechnical reports because the 1978 data shows a hazard near or on the property. Any questions about that?
I was following you pretty well until that last sentence.
Okay. Well, previously, up until now, our comprehensive plan and our ordinance says that if there's an identified hazard near or, if there's an identified hazard that may affect this property, that we need to require a geotechnical analysis before we issue a building permit. And geotechnical reports cost, maybe $5,000. So we kind of hate to ask for those when we're not sure whether the symbol on the hazards map really is showing a potential hazard for a specific property. The only way that we could make that determination would be, to consult a specialist, a geologist.
So if you take your only base data that you apparently have now, which you've got the coastal erosion data, which is hard, recent, and digitized, if you will.
Yes.
you've got 1978 data that currently forms the basis of your other decisions. Now you're saying, if I understand what you've written, instead of it being the criteria that says if you are, for example, within this area on the 1978 map, you now or you currently have to do a geotech study, right?
That's what our ordinance says.
And where we're going then is to remove that requirement that the 1978 hazard data causes, in all instances, a geotech to be required, correct?
Right.
Then what is the new criteria for the city to require a geotech?
Only the coastal erosion data.
So any other area that's a potential slide, for example, the areas on 101 that are up there in the air, or any other area of historic slides are not, there is then no requirement that a future developer submit a geotech.
That's correct. And what we are saying is that we would inform the applicant that we have a hazard in the vicinity shown on our 1978 map, so that they are aware of it, and it's their responsibility to seek professional advice.
All right. Let's say, I, as a developer, come back and say, I don't choose to do that. I don't want to do the soils, I don't want to do a geotechnical analysis. Then, let's say there are properties below that. The city then has no role in the protection of those properties that are adjacent, below, or potentially impacted. That is the result of it.
Yes.
All right, let me give you a specific example here from my business, building cell towers. Every time that I've built thousands of cell towers, I've been required to submit a geotech and a structural. What you're saying in this case is that's no longer a requirement in Lincoln City, unless I'm in that coastal zone.
I would have to check our code as far as cell towers, because we may still require engineering on that. I imagine we would, anything of that height.
Cell towers have to be engineered. I think what you're getting at, though, is there still are requirements through the building code for engineering of foundations and so on. And it's more and more in almost every case, except for some single-family homes, there has to be engineering done. So
we're not opening, in your opinion, the floodgates.
No, I don't think so. And also, we, as part of the coastal hazards thing, the DOGAMI, the Department of Geology and Mineral Industries, also looked at slide areas, and there was very, very potential slide areas. There's very, very little in Lincoln City. Some along the coast there's a small area along the coast, where our current map has huge areas that say massive ancient slides.
But they're only drawn as arcs.
They're drawn as arcs, so we can't. So there's sort of three possibilities of what that means. One is everything on the downslope side of that is a problem. Everything on the line is a problem because there's a potential scarp there. Or everything above it has a problem because the slide's already happened and there may be more sliding uphill from it. And we don't know what it means. We're going to DOGAMI. You say, what does this really mean? And they go, I don't know. So we go to the experts and they say it has no meaning, then we have a real problem requiring people to do something about it, where we can, on a case-by-case basis, where the building official is saying, this needs engineering, this needs a geotech or something to deal with it.
So you're saying this more directly impacts the land use portion and building permit portion.
Right. Okay.
Right.
the building code specifies when engineering is needed, and oftentimes the engineer will consult with a geologist about foundations. But in this case, our code is requiring the geotechnical report regardless, yeah. So that's why we're not comfortable really doing that. Yes.
Yeah, I was just reading the ordinance here, or the code, 47.
Okay.
It talks about your 1978.
Yes.
Then it goes, for the purpose of this chapter, in case of conflict between a site source and the supplement of the 2004 Priest and Allen report, map as also will prevail.
That's what it says now. Yes. Okay.
You're saying you're going to replace that in the ordinance?
What we are proposing now to do is to say that anything shown on the Priest and Allen as coastal erosion hazard needs a geotechnical report. Anything that we have from the 1978 data will be advisory only. So, we'll inform people, we'll have it on our GIS, and we will suggest that they should seek professional advice for anything that appears to have potentially a hazard on it.
Is there a updated Priest and Allen report from 2004? Have they updated that
No,
one?
that's their big
That's
their big report.
That's perfect.
And George Priest was here a couple times last year to speak to the Planning Commission and the council, explain his work. And we also had, at the council level, we had 2 different geologists who were weighing in on this and our changes that we made.
Was he the gentleman from the state geological department?
Yes. He has an office in Newport. And he was the man who was instrumental in getting our tsunami warning areas, the signs posted, and getting the maps produced. So he's been very involved and very conscientious. And they also did the landslide data, but they're not as confident that they have that was an exhaustive study and that everything's identified. So that's why we didn't go there. But it appears that, as Richard said, there are very few slide areas that present hazards now in the city.
Could I move beyond the second bullet point
Okay?
for a moment?
Yes.
Exceptions to what requirements?
To the requirements for geotechnical analysis.
So any of those, number one, we're doing away with the requirement for geotechnical analysis, right?
Yes.
So an exception is,
Cases required.
The third bullet point says exceptions to the requirements. And we're talking about minor maintenance, repair, alterations, construction on a portion of the lot outside the hazard zone. Right now, the coastal erosion data basically applies to all the lots fronting on the ocean.
so we still then have a requirement for geotech in the zone identified by the 2004 study.
Yes, that's the
But
standard.
These listed are exceptions to the geotech requirement for
Yes.
that area.
Yes.
Is that correct?
That's
Yes.
correct.
So, and these are, because we feel they're minor. And in the case that the 3 coastal erosion hazard zones don't cover the whole lot, and the addition or the proposed structure is outside, then we want to we don't want to require.
Okay, makes sense.
All right, anything else on natural hazards? Okay, clear vision. Now, I thought this would be the controversial one, but
We're just warming up.
we're just getting going. Okay. All right. We have two sections in our code right now about clear vision, and it is not clear exactly what it means. So the clear vision triangles are those areas at corners where two streets intersect, or a driveway intersects with a street or an alley. And the idea is that we want to make sure that cars approaching, kids, pedestrians, bicyclists approaching can see the oncoming traffic from the other way.
Yes. I'll just interrupt real quick. I don't know if it makes a difference, but I want to let you know none of the stuff that you've gotten past the garage setbacks is on this agenda tonight. So I don't know if that's going to make a difference for public hearing or.
Is this one up on our most recent?
What you're looking at is what's scheduled for the next hearing under item number 10.
Right.
But what she's discussing is everything that you'll hear in August, at both of the August meetings. So.
Okay.
Yeah.
It's not listed on here. You got to garage setbacks for the future items, and then that's where it's going. It stopped.
Okay.
Yeah, this agenda item is intended to give you a good kind of background and summary on all of the amendments for both of the August meetings.
Okay, and this is the last one.
Okay, I didn't know if it made a difference for. Okay.
All right. Okay. So, no, this is just an informative session here. So, okay. So, the thing that I would call out on the intent and purpose is that the last couple lines here, the clear vision areas at local intersections shall meet the requirements. Let's see. This section is meant to be adequate to allow drivers and pedestrians who are stopped or approaching with caution to see intersecting traffic in time to avoid collisions. Local clear vision requirements are not designed to enable motorists to avoid slowing at intersections. And I mean, okay, so, and I mean, that's you know, other people may have a different idea about what clear vision should be. I worked in a city where the city manager was also the city engineer, and he wanted to apply 75 feet. You know, you wanted a 75-foot triangle so that you wouldn't have to, you just keep going at your speed and you could go right through. So anyway, that's I wanted to preface the changes with that intent and purpose. I will also mention that the Highway 101 intersections will be to a different standard, and I did get some feedback from our regional planner from ODOT. First he said they were fine, then he came back and said, I'd really be more comfortable if you beefed up another section of the code that addresses that specifically. So we'll take a look at that before we get to the end of this.
There's some scary access on 101, 14th and 101.
Yes.
Green building. You sort of stick your nose out when the light changes and hope you survive it. The zero setback on a lot of those commercial stuff is.
Well, and another concern is that, like, a skateboarder came flying down the sidewalk in front of me the other day when I was at that exact corner. So, yeah, it is nice to be able to see around the corner a little bit.
But none of these changes will take effect until the property changes hand, because we're not going to make the current property owner at that corner tear down a concrete wall that's been there for the last 20 years.
Well, and actually, these changes are making the requirements, they're lessening the requirement for clear vision in local streets, on local streets. Right now, and I'll show you this slide here, right now we're defining the clear vision triangle as having 30-foot sides, and we're reducing that to 16-foot sides. And the way we came up with 16 feet, and we thought gave a lot of thought to this, and it seemed like the more we thought about it, the more complicated it got. If we were talking about traffic speeds and or width of street or whether or not there was any traffic control, like a stop sign or a yield sign. But in the end, we thought that maybe this was the best approach. 16 feet is usually the distance back from the intersection of the curb lines for a stop sign. So this, we are using, though, not the intersection, or the intersection of the edge of pavement. We are using the intersection of the property lines at the corner, which would push it further back into the property, so it would give a little more setback. Do you understand what I'm talking about as far as the triangle? Okay, I will use, let's see, we'll start with this example over here. I am on the property line where the property lines intersect at the intersection of the two streets. Is our point of beginning, and we go 16 feet back along the property lines in either direction for the first two legs of the triangle. The third leg connects those two endpoints. And that would be the area that would have to be clear of obstruction between 2.5 feet and 8 feet in height.
The hypotenuse.
Pardon me?
The hypotenuse.
The hypotenuse, yes. So, when you apply that to, you can see how it applies, and it does vary because sometimes we have a lot wider right-of-way, and so it pushes it back a lot further. We considered saying the edge of pavement, so our triangle would be out here. But then what happens when we decide to put in a sidewalk, or we decide to maybe widen a street or put in parking or something like that, then all of a sudden you've got a structure that's too close. I had a property owner in last week saying he would much prefer it to be on the pavement lines, and then we got into discussing, well, it's more important for buildings, say, to be set back a safe distance than landscaping, because if you had to put in a sidewalk and remove some landscaping as a result, it would be much less costly, and you might actually be able to move the plants and so forth. We didn't go there. It's something we can consider if that's, if you want to make that kind of distinction. But for right now, we are proposing the 16-foot, and that's a decrease from the 30-foot triangle. And I spent some time, you've all driven around the streets here. There are lots of places where we don't have 30 feet right now, and people slow down as a result, and they have to maybe creep out to go around the corners. We're trying to strike a balance between being safe and accommodating the topography we have here and the kinds of streets we have here and the traffic that we expect. The more that you widen that triangle and provide a clear view, the more inclined the drivers are to pick up speed or maintain speed through the intersections. So that's the trade-off. And you'll see in the newer areas of town where we have some really deep setbacks. I believe up here, this is maybe in the northwest, and we've got some large radius curves, and so the triangle is actually clear out here, so it really wouldn't affect the private property. But you also have some front yards that extend out and have a larger clear area. Whether that's necessary and applicable to our older streets and other areas of town, is what I guess we'll discuss at the hearing. Yes.
One area that I've noticed a real clear vision problem is with the crosswalks that are put into the 101.
Mid-block?
Mid-block crosswalks.
Yes.
And particularly the one by Bob's Beach Books. And whenever there's a large box van or something like that that parks right up to the yellow mark as a driver, I cannot see the pedestrian that's starting to cross the street.
Yeah, I've had the exact same situation, same crosswalk.
And
yeah.
if we're going to be talking about 16 feet, I think we need particularly, we're talking about having a walking path plan and other things like that to encourage bicycles and pedestrian mobility. We need to look at that safety issue there pretty closely, because there have, I can't count the number of times that I've seen people that are invisible until they get to the middle of the crosswalk.
We've been discussing that with our walking and biking study that we've been doing this past year, and we have also talked to some ODOT people about that. And the crosswalks really don't fall into this, because this is defined by intersection of two streets or alleys and driveways. But the crosswalks, one of the things that the bike and pedestrian specialist at ODOT has said about those is that we have bump outs, but the bump outs don't extend far enough to get people past the parked cars. And that's an identified problem that we could address fairly simply through just, striping and also, extending those bump outs.
Or take that bump out by Trillium and move it up onto 101.
Bump out on Trillium.
The one I drive over every time I make a right-hand turn there.
Okay. All right. Anyway, so, we've recognized that problem, too, and there's been some discussion about it, and hopefully we'll be addressing it with ODOT.
Thank you.
Question, I remember when I first heard about this, there was discussion about the chain link fence versus the solid wood, and we're going to allow the chain link fences to be defined as a clear.
Okay, well, because it's so small now, it's we've reduced it down a lot. That now is something that we could discuss again. The exceptions that we've proposed to this limit of obstruction between 2.5 feet and 8 feet include trees existing in the location prior to the date of the ordinance, as long as they're limbed up to at least 8 feet. And that they would not be able to be replaced in that location. Topographical features and principal buildings, accessory buildings, and structures existing as of the date of this ordinance. So we did not address the fence issue.
Okay.
And because it's been reduced so much in size that it didn't seem as significant
But no one
an
would
issue.
be denied a permit to erect chain link fence because of this?
We don't permit fences, but
We don't issue permits for
we don't.
fences.
Oh, okay.
Yeah, that's right. I'm sorry.
We don't issue permits.
I used permit in the wrong
Okay.
way, but. And I will also mention that we have this one caveat here that the following may be allowed unless identified by the city engineer and planning director as being unacceptable.
And then trees includes any kind of shrubbery?
Well, this is one thing that the property owner who was in last week asked me, what's the definition of a tree? And I believe in our ordinance we do have a definition of a tree. I don't think so. No, because when you're limbing something up to 8 feet, it would have to be, like most shrubs that would be a strange-looking shrub, essentially.
No, because I have one right by my house where the house was built with a rhododendron that was this tall, and it is now 4.5, 5 feet tall, and I cannot see around that corner. I have to creep to the corner, and it's
Right.
a rhodey.
Okay, and so if it's
Pampas grass, they get
okay,
huge.
so if it isn't limbed up to 8 feet, then it would not fall within this exception.
Yeah, I guess maybe what you're suggesting is, are we missing part of the issue? Because trees are the easy ones to solve by limbing.
Right.
But a shrub or a grass that is 8 feet tall,
Is not allowed.
So at some point, someone,
it says that somewhere else.
Well, nothing, okay, I didn't start at the top. Clear vision triangles shall be free of obstructions from 2.5 feet to 8 feet above the point of intersection of the triangle legs that we are making an exception for trees if they're limbed up.
Limbed up, so.
Okay,
but
so nothing else
something
is-
that exists now,
except
it's
these
there, and
exceptions.
it's tough, and that's the way it's going to be. There's no way to improve, to go to approach that owner and say, look, your bush is grown now.
Right, well, no, if it's an obstruction and it's within the clear vision triangle, then the city can require it to be removed.
If it's taller than 2.5 feet.
Right.
Got it. Okay.
Or at least trimmed back
Got it.
to 2.5 feet.
Okay.
Just trying to create some
That's it.
controversy here for you, Deborah.
Okay. That's it. So those will be the ordinances we'll be looking at next month.
That was easy.
Yeah.
We get to do it all over again.
Yes. In more detail.
But we'll see all these changes based on our
Well, now, and this is a good question, because once we send off the draft ordinance to DLCD, and we mail it to all the residents in the city, and so we do not really want to confuse those people who received that ordinance by changing it before we bring it to the Planning Commission hearing. So,
Excuse me, what you're saying is that this presentation and our comments are not going to be input for any of the changes that we're being asked to do.
what I'm saying is that, to avoid criticism we've received in the past when we've changed ordinances before we've brought them to the Planning Commission for hearing. This has come up before. It seems like it comes up every time. We propose an ordinance, and then we get more input, and we have, a brainstorm or a second thought, and we want to make a change before we actually submit it to the Planning Commission for hearing. And then those people who received it in a mailing at their home come and they say, wait a minute, we came prepared to talk about this, and now it's changed, and we didn't know. We do always put any later revisions up on the Internet. But what I'm saying is that, no, we appreciate your comments. We will research them. We'll figure out responses to them. And and we can actually provide you with some language for ways to revise what we're presenting at the hearing. And then, when you make a motion or a recommendation to council, you can do so with revisions.
All right, so there is the process does include our ability at the actual formal meetings to make changes based upon the comments we've made tonight.
And what you hear from
Right.
the public at those
Hear
meetings.
from the public.
Yes.
And so that our discussion tonight is not
No.
academic.
Oh, no, we took lots of notes, and this is kind of just a heads up for you, so you're prepared for the public hearing, and you've given this some thought in advance, and we will try to respond to all the questions you've raised.
Thank you.
Yes, you're welcome.
All righty, number 9, reports and comments. Richard.
I have, I guess one thing I report on, we had another public event this weekend for the walking and biking plan during the farmers market. We had a tent, and our consultants and staff people were there, and we had a lot of people come through and give input on their preferences for the kinds of things we need for walking and biking, and how we pay for it, and so on. So we had a lot of turnout there. It went really, really well. Beyond that, I don't think I have anything.
Okay, thank you. Deborah, did you have any additional comments?
Well, I'll just that we were invited to also participate at the Devil's Lake Revival event. And what date is that, Kate? Do you remember?
It is Saturday, August 4th. I don't know the exact times, but I think it's midday.
And that's the walking and biking also. So we're trying to get out to as many people as we can. And we do have the Facebook page and the website.
Thank you. Joan, do you have any comments?
No, thank you.
Okay, Planning Commission? anything?
I got one thing I wanted to say. I told our kids I would say this tonight if any of them are watching, but our youth league rookie baseball team finished their all-star summer ball, went 19-2, won every single tournament that they played in, from Reedsport, Florence, Newport, and we finished up Sunday night here. So they were something they've never happened before. So
Congratulations.
3 cheers.
Super. Okay. Public comments on non-agenda items not involving a public hearing? No public. Number 10, future agenda items and next meeting.
The Tuesday, August 7th, at 6 p.m. at this location, we'll have the zoning ordinance amendments, the sign ordinance amendments we discussed tonight, miscellaneous amendments, and the garage setback amendments.
All right, looking forward to that. All right, thank you, everybody. We're adjourned.
good job.